I often get queries very, very regularly actually from employees who are concerned, who are thinking about leaving their job or have left their job, and they're concerned about the so-called non-compete clause in the contract of employment of the contractor of the job that they've left. This non-compete clause is also known as a restrictive covenant. So it will be described in the contract of employment as a restrictive covenant. The bottom line is it would seek to restrict the employee who leaves from working with a competitor or in the same industry for a certain period of time, maybe 6 months, maybe 12 months, etc. And when the employee comes to me, they're always asking me, oh, is this enforceable? And are my old company likely to enforce it? And I always say the same thing, yes, it is enforceable, provided it's reasonable. And secondly, I've no idea whether their old company, their old employer is going to enforce it or not. And the reason for that is some companies do, some companies have plenty of resources and choose to enforce these restrictive covenants, these non-compete clauses. Other companies will use them in their contracts as a sort of a threat, but they may never pull the plug and actually commence legal proceedings. There's a case though reported in the newspapers this morning about a High Court injunction obtained in the medical device industry, where a former manager with a medical device firm has been prevented from working for a rival firm on foot of an injunction obtained by the old employer. This case is instructive and it will be an interesting one to see the outcome of. So there's a temporary injunction for the moment, pending the hearing of the action, which is scheduled now for July. The background is that Craigana have been granted a temporary injunction against the man, Niall Cullen, from taking up employment with a competitor, Lake Regional Medical, pending the hearing. The High Court granted the injunction, preventing this guy from leaving his employment and taking up with a rival firm, pending the hearing of a dispute over whether the employment was governed by a non-compete clause. He was the product manager with Craigana Limited, an Irish company based in Galway, and he was offered a senior position with a competitor, Lake Region Medical. Craigana operates within the TE Medical business unit of a global business known as TE Connectivity, and this is in turn owned by a Swiss company. So this company obviously would have the resources to go to the High Court, no difficulty, and seek an injunction and run the risk with the various the legal proceedings that might follow. Last January, Mr. Cullen, he had been the senior product manager of Craigana, key role in maintaining relationships with key decision makers in a number of global customers or companies. He handed in his notice, which ends on April the 29th. Craigana learned that he was taking up a senior position with Lake Region Medical. This is a competitor company. It brought High Court proceedings seeking to prevent him from taking up employment after April 29th because Craigana said he would be in breach of a non-compete clause in his contract, which prevents him from taking up employment with a competitor within 12 months of the termination of his employment. Craigana says that this restrictive covenant, this non-compete clause, was required to protect its legitimate interest in maintaining the confidentiality of its highly sensitive commercial information, which it says will invariably be compromised if he took up the position with Lake Region Medical. And this non-compete clause, remember, which Craigana is saying is there to protect its legitimate interest, that's important because that will be something which will go to the question of whether the restrictive covenant, the non-compete clause, is enforceable or not. If it is to protect a legitimate interest of this employer, well then that would be certainly a tool, a piece of armoury, as it were, that would be strong in their attempt to enforce the restrictive covenant. In other words, they have a legitimate interest to protect. Mr. Cullen and Lake Region, the new employer, which is also being sued, and that's typical. Not only will the old employer threaten to sue the employee who is leaving, but they'll also threaten to drag in the new employer to any legal proceedings. Mr. Cullen says that the non-compete clause is void and unenforceable because it's unreasonable and too broad to be justifiable. The judge said he was satisfied that Craigana had established that there was a serious question to be tried if Mr. Cullen takes up the new job, and this would be an actionable breach of contract by being a breach of the non-compete clause in his contract of employment. He was satisfied that Craigana has raised a serious question to be tried that the non-compete clause is valid. He was also satisfied that as Craigana was prepared to undertake to pay Mr. Cullen his salary until the conclusion of the trial of the action, which is now scheduled for next July, there was the least risk of injustice by preserving the status quo pending determination of the matter or further order. The judge also requested Mr. Cullen's claim that Craigana was guilty of delay in bringing its injunction application. I don't see it in this report that I'm reading here, but I think I saw it yesterday and somewhere else, that the non-compete clause that's in the covenant or in the contract of employment is for 12 months, and Mr. Cullen and his legal team will be arguing that 12 months is too long a period of time, that 6 months generally would be seen as reasonable and enforceable, whereas 12 months may seem excessive and may seem unenforceable and may seem to be a breach of a person's constitutional right to earn a living. However, it would depend on the circumstances, and Mr. Cullen obviously would have seen or should have seen that there is a 12-month restrictive covenant in his contract of employment when he was signing up, and he may well have agreed to it and he may well have signed up for that. But as I say, his argument will be that this is too restrictive, it's too long, quite frankly, and it infringes his entitlement to earn a living, his constitutional right to earn a living. That case then is going to be heard, the full case will be heard in July. The outcome of it will be interesting and I'll certainly be very interested in it, because, as I say, I get a lot of queries from employees who are threatened with being sued basically by their old employer and on foot of a restrictive covenant or non-compete clause. I hope you find this video useful. If you do, I'd appreciate if you gave it a thumbs up down below. Thank you very much.